I had exactly $218.43 in my checking account, a sling around my right arm, and a padded manila envelope sitting on the passenger seat beside me when I learned my brother had tried to empty what was left of my mother's estate. 2 weeks earlier, I had been discharged after shoulder surgery I could barely afford. 9 days before that, I had buried my mother. The envelope had been handed to me in the church parking lot by a woman I didn't recognize, and inside it was a flash drive labeled in my mother's handwriting with 3 words, "For when necessary." I dropped it once trying to get it into my laptop because my left hand was doing all the work and my fingers were shaking harder than I wanted to admit. By the time I opened the first file, I understood 2 things. Someone in my family had moved faster than grief should allow, and if I let them stay 1 step ahead of me, the law would do the rest for them. Let me take you back. My name is Nora Hensley. I was 47 then, living in Columbus, Ohio, and working as a procurement analyst for the city school district. I was good at rules, calendars, paper trails, and the kind of details other people skipped because they assumed someone else would catch them. My flaw, if I am being honest, was that I had spent most of my life believing competence could smooth over character. If I stayed calm enough, organized enough, useful enough, maybe the people around me would eventually become fair. That is not how fairness works. It took me too long to learn that. My mother, Diane, died in late February after a fast decline that still does not feel fast when I think about how long the days were. She had congestive heart failure, then pneumonia, then 1 bad week that turned into the final week. My brother, Eric, lived 20 minutes away in Dublin with his wife, Melissa, and their 2 boys. I lived across town in a small condo I had bought after my divorce. Because I had a more flexible job, and because I had always been the one who handled forms, appointments, and medication schedules, most of our mother's care landed with me. That part was not unusual. In our family, Eric was considered the people person. I was considered the reliable one. He got thanked. I got handed things. There were 2 incidents from childhood that should have taught me the full shape of that arrangement much earlier. The first happened when I was 14 and Eric was 17. He backed my mother's station wagon into the neighbor's mailbox, then told her I had left my bike in the driveway and caused him to swerve. My mother looked at me, looked at him, and said, "Nora, you know how your brother gets when he's rushed. Why add to it?" I remember standing there thinking that the apology had somehow become my responsibility simply because I was easier to reason with. The second happened at my father's retirement dinner years later. Eric introduced me to one of Dad's co-workers by saying, "This is my sister Nora. She handles the boring things so the rest of us can live." Everyone laughed. I laughed too. That was the dehumanization of it. Nobody had to say I was less important. They just turned me into a function and let the joke do the work. By the time our mother got sick, my father had already been gone 6 years. He had left behind a modest estate plan, a revocable trust, a duplex on the west side that my parents had rented out for years, a small brokerage account, a checking account, and a clause my father insisted on because he distrusted improvisation. He called it his canary clause, though the attorney used more formal language. If any beneficiary submitted fraudulent paperwork, concealed assets, or interfered with trust administration, that person's share could be reduced to $1. My father had made the lawyer explain it twice at the signing. He said, "If anybody gets clever after I'm dead, I want clever to be expensive." At the time, Eric laughed and said Dad watched too many court shows. After Dad died, Mom made only minor updates. She left me as successor trustee because, in her words, "You read the fine print and you don't scare easy." Eric did not object then. He objected later, but only when money became real enough to touch. The surgery came a week before Mom passed. I tore my rotator cuff slipping on wet concrete outside a pharmacy after picking up her prescriptions. I remember lying there in the parking lot, embarrassed before I felt pain, because people were staring and I hated causing a scene. By the time I was discharged after the repair, I was in a sling, sleeping badly, and handling hospice calls one-handed. Mom died 4 days later. Eric cried at the funeral. Melissa cried too. I do not say that to be cynical. People can cry and still be dishonest. Those 2 things are not opposites. The public event where everything started to tilt was the memorial luncheon after the service. It was held in the church fellowship hall with trays of baked ziti and deli sandwiches nobody touched until the pastor insisted. I was sitting at the end of a table, signing reimbursement forms from the funeral home because Eric said he had left his reading glasses at home, when he leaned down and said, very softly, "You should move fast on the duplex. The market's weird. No point sitting on dead assets." He said dead assets less than an hour after we buried our mother. I looked at him and said, "We haven't even opened the trust administration." He shrugged. "I'm just saying don't make this harder than it has to be." Melissa added, "And don't turn it into one of your process things." That was how they talked when they wanted to make caution sound hostile. I put the pen down. Then I picked it back up because there were signatures needed and people waiting, and my arm ached, and grief makes you choose the nearest task. 3 days later, I got the envelope. The woman who handed it to me was named Lila Benton. I knew her only as one of the church bookkeeping volunteers, a quiet woman in her 60s with silver hair and practical shoes. She approached my car window after the luncheon cleanup, tapped once, and said, "Your mother asked me to give you this only if something started to feel wrong." Then she walked away before I could ask a second question. At home, I plugged in the flash drive. There were 2 folders. The first folder contained scans of utility bills, insurance records, tax returns, and handwritten notes from my mother. Normal things. Helpful things. The second folder changed everything. Inside it were PDFs of emails, screenshots of text messages, and a video file from the office printer scanner in my mother's condo building's shared workroom. I did not know a printer scanner could store metadata until that night. Every scan had a timestamp, device ID, and user login attached. Someone had scanned Mom's old signature pages from prior trust documents 3 weeks before her death, late at night, using the guest login in that workroom. The attached screenshots showed Melissa texting Eric, "Need the clean signature page, not the one with notes." And Eric replying, "Nora won't move fast enough. We'll fix it before she notices." I sat there with the laptop on my kitchen table and my good hand pressed flat against my thigh to stop it shaking. There was more. A draft quitclaim deed for the duplex. A caregiver reimbursement summary showing $86,000 in expenses that had never been approved. A typed note in my mother's files, clearly written by Mom because I recognized the phrasing. "If Eric pressures after I'm gone, tell Nora to check dates, not stories." The next morning, I called the attorney who had drafted the trust, Judith Pell. She listened without interrupting, which I appreciated. When I finished, she said, "Come in today. Bring the drive. And Nora, listen carefully. If you miss this, you lose everything." That sentence had weight because she was not dramatic. Lawyers who do estate work for 30 years do not raise their voices for effect. She explained that a deed could be recorded quickly if someone had a notarized-looking signature and enough confidence. Funds could be moved under the cover of reimbursements. If false documents entered the county record before we filed objections, unwinding them would become slower, more expensive, and less certain. Grief did not pause deadlines. Fraud counted on that. Judith had me sit in her conference room with an ice pack under my shoulder while she reviewed the files. She explained each term as she went because she knew I hated legal language used as theater. A quitclaim deed, she said, could transfer whatever interest the signer had, even if the transaction was suspicious. Trust administration required notices and inventories. An affidavit would preserve my sworn account. Metadata could help establish when files were created and altered. A forensic audit might be needed if money had already moved. If the canary clause applied, it would matter only if we proved intent, not just sloppiness. At one point I said, "This sounds like revenge." Judith looked up from the screen and said, "This isn't revenge. This is justice." The distinction mattered. Revenge is emotional. Justice is documented. That afternoon, we filed a petition to freeze transfers related to the duplex and a notice with the county recorder flagging a dispute over authority. We also sent preservation letters to the bank and to the condo association that managed Mom's building. Judith wanted the security footage from the shared workroom before it rolled over. I drove there myself because waiting for someone else felt impossible. This was where the ally identity twist entered the story in a way I still think my father would have appreciated. Lila Benton, the church bookkeeper who had handed me the envelope, was not just a bookkeeper. For 21 years, she had worked in the Franklin County Recorder's office before retiring. She knew exactly how fraudulent deed filings looked when people tried to rush them through. She knew the kinds of mistakes nervous people made. And she knew my mother had come to her 2 months earlier asking a very specific question. What protections existed if a child tried to record property paperwork after a parent became weak? Lila sat with Judith and me 2 days later and said, "Your mother was not paranoid. She was preparing." The security footage arrived on a thumb drive from the condo association. We watched it in Judith's office. At 9:42 p.m. on a Tuesday, Melissa entered the workroom alone. At 9:47, Eric joined her. He carried a folder. They scanned several pages, paused, argued, rescanned, and left at 10:11. There was no audio, but the timestamps matched the scan logs on the flash drive. The hidden angle was not dramatic. It was almost boring. That was what made it so useful. Fraud rarely looks cinematic in real life. It looks administrative. Judith then subpoenaed bank records for the estate-linked accounts. That was where the money showed up. Not the full estate, but enough to tell the story. Eric had submitted reimbursement requests for private overnight care, specialized nutrition services, transport coordination, and home safety modifications, totaling $143,600 over 11 months. Some of it had actually been paid from Mom's checking account while she was alive because he had online access for emergencies. Most of it was fake. One vendor was an LLC registered to Melissa's cousin. Another address led to a UPS store box. The bank investigator used the phrase irregular disbursement pattern. I liked that phrase because it was calm and damning at the same time. The villain escalation came when Eric realized the county recorder had flagged the duplex transfer. He called me on a Friday night and opened with, "You are making the worst mistake of your life." No hello, no concern, just position. I put the phone on speaker because my shoulder hurt and I was tired of holding devices to my ear. I said, "You filed a deed on property you don't control." He said, "Mom wanted me protected." I said, "Then she could have amended the trust." He said, "Judith's filling your head with garbage." I said, "The deed won't stand." Melissa got on the line then, which she did when she thought a female voice would make something sound more reasonable. She said, "Nora, be honest. You always resented that your mother trusted Eric with personal things." That sentence was almost impressive in its shamelessness. I had taken Mom to 83 appointments over 3 years. I had managed her medication chart, her insurance appeals, her oxygen equipment, her taxes, and the sale of her old Buick. But because I was not sentimental in the right public way, they thought they could recast competence as coldness. Eric's voice came back. "Drop this, or we open up every receipt you ever submitted. Every gas run, every pharmacy charge. We can make this ugly." There it was, the humiliation threat. Not only theft, but the promise to muddy the waters so thoroughly that telling the truth would feel indecent. I said, "Do what you need to do." Then I put the phone face down. Judith moved faster after that. She petitioned for a temporary restraining order barring any disposition of estate assets. She retained a forensic accountant. She had me prepare a clean ledger of every expense I had ever submitted for Mom, with dates, receipts, mileage logs, and matching calendar entries. It was tedious. It was humiliating. It was also the right move. Truth survives scrutiny better than performance does. The public set piece arrived 6 weeks later at a scholarship banquet hosted by the neighborhood foundation my mother had supported for years. Eric was on the foundation board. Melissa had already been telling people I was struggling emotionally and misunderstanding estate matters. They had counted on social pressure, on donor room politeness, on the fact that most people hate scenes more than they hate dishonesty. Judith asked whether I wanted to attend. I said yes. The banquet was held in a renovated downtown hotel ballroom with round tables, weak coffee, and a string quartet playing songs nobody fully listened to. Eric moved from table to table in a navy suit, shaking hands like a man auditioning for a larger life. Melissa wore cream and carried herself with the confidence of someone who believed paperwork was just storytelling on better paper. The dramatic irony of that night was simple. They thought they were still ahead. About 20 minutes into the dinner, after the student speaker and before the donor recognitions, a process server handed Eric an envelope near the stage. He tried to smile through it. Melissa took one look at Judith standing beside me and understood more quickly than he did. The first reveal was small. The injunction papers, just enough to take color out of his face. The second reveal came when Lila Benton, in a dark green jacket and reading glasses, was introduced by the foundation director as a last-minute substitute treasurer to deliver a financial compliance note. That had not been an accident. One of the larger donors, a widower who had known my parents for years, had learned through church gossip that estate property might be tied up in fraud proceedings. Donors do not enjoy legal uncertainty attached to their boards. Social twist. Visible. Useful. Lila stepped to the podium and said, in a voice so steady it almost sounded kind, that pending litigation had raised governance concerns involving a current board member, and the foundation would be postponing the vote on a planned real estate partnership until all fiduciary questions were resolved. She did not say Eric's name first. She let the room arrive at him together. The third reveal was nuclear only because Eric forced it there. He stood up and said, "This is a family misunderstanding being weaponized in public." Judith rose from our table and said, "Then let's be precise." She handed the foundation director copies of the county notice, the bank investigators' preliminary findings, and stills from the condo workroom footage with timestamps. Not gossip, not accusation, documents. Melissa started to say something about privacy. The director said, "Is that you in these images?" Nobody answered fast enough. I remember looking around the ballroom and seeing not outrage, but withdrawal. Board members shifting chairs back by inches. A donor setting down his fork. A pastor turning over a page too carefully. Public shame in adult life is usually quiet. It is people deciding, in real time, not to stand near you. Eric and Melissa left before dessert. 3 months later came the hearing. By then, the forensic audit had tracked the fake reimbursements into 2 LLCs, one controlled by Melissa's cousin and one registered to Eric himself through a mailbox service in Delaware. Judith had the filing histories, the wire records, the invoice templates, and the metadata showing the invoices were created on Melissa's laptop after the dates they were supposedly issued. She also had testimony from the notary whose stamp appeared on the quitclaim deed. The stamp had been copied. The notary had not been present. That turned a bad family fight into straightforward fraud. When Eric took the stand, he tried the same tone he had used on me for years. Calm, slightly offended, patient with everyone else's supposed confusion. He said he had acted based on verbal wishes from Mom. He said Melissa had handled paperwork because he was overwhelmed. He said any discrepancies were unfortunate clerical issues. Then Judith introduced my mother's flash drive, Lila's testimony about Mom's preemptive concern, the scan metadata, the surveillance footage, and the canary clause. She asked him, "Did you or did you not submit reimbursement requests to the trust using invoices generated after the services were allegedly performed?" He started to answer around the question. She asked again. He said, "I would need to review the documents." She said, "You created the documents." The courtroom went silent. Not movie silent. Air conditioning silent. Pen stopped moving silent. Judge looking over glasses silent. The order came in stages. The court invalidated the quitclaim deed. The restraining order became a longer injunction. Eric was removed from any role touching the estate. The fraudulent reimbursement claims were disallowed. Because the judge found intentional interference with trust administration and fraudulent filings, the canary clause was enforced. Eric's share was reduced to $1. Melissa was referred along with him for further review related to the fabricated notarial page and false invoices. There was no dramatic gasp. There was just consequence. Real consequence is procedural. It lands in paragraphs. The duplex was sold 6 months later. After debts, fees, taxes, and restitution adjustments, enough remained for me to stabilize my life in a way I had not realized I had been postponing for years. I paid off my surgery balance. I replaced my car with a used Subaru that started every morning without negotiation. I took a week off and slept more than I had in months. I put part of the money into an irrevocable education trust for Eric's boys, because whatever their parents had done, they were still my nephews, and my mother would not have wanted the next generation drafted into old hunger. Eric sent 2 messages through his attorney. The first requested mediation about family reconciliation. The second objected to the educational trust on grounds that it was performative. I did not respond to either. The boys would have the money for school. That was the end of my conversation with that subject. 1 year later, I was still living in the same condo, but it felt different because I no longer walked around it like a temporary guest in my own life. I painted the kitchen myself after physical therapy ended. I planted herbs on the balcony, even though I had killed basil twice before. Lila and I had lunch once a month. Judith sent me holiday cards with unusually sharp handwriting. And on Thursdays, after work, I volunteered with a neighborhood legal clinic doing intake forms for elderly clients who needed help sorting title records, beneficiary designations, and small estate affidavits. Nothing glamorous. Mostly copies, checklists, and listening. It turned out my old skill set had a second life waiting for it. As for Eric, he resigned from the foundation board before they could remove him. The company where he worked let him go quietly after the court filings became public record. Last I heard, he and Melissa sold their house and moved farther north. I do not know whether they are happier. I know only that distance can look a lot like peace when you have earned it. Sometimes people ask whether I miss my brother. I miss the idea of a brother. I miss the version of the future where loyalty did not need proof. But I do not miss confusion. I do not miss being told that caution is cruelty or that documentation is distrust. My mother gave me one final gift in that envelope. Not just evidence. Permission. Permission to stop translating betrayal into misunderstanding. The truth is, boundaries are not cold. Boundaries are how self-respect sounds once it stops apologizing. If you have ever had to choose between keeping the peace and keeping the facts, you already know how expensive that choice can become. So I'll ask you this. At what point would you have drawn the line? And if you want more stories about quiet justice, legal consequences, and people who finally stop confusing love with permission, subscribe and stay with me.